What rights do creditors have in bankruptcy? Imagine you lent money to someone who is now filing for bankruptcy. You might wonder what your options are and what rights you still hold. When a person or business files for bankruptcy, creditors have specific rights that protect their interests. These rights depend on whether their claims are secured or unsecured and what type of bankruptcy is involved. Knowing these rights can help you avoid common mistakes like missing important deadlines or not asserting your claims properly. First, creditors have the right to receive notice about key events in the bankruptcy process. This includes when the bankruptcy petition is filed, when meetings of creditors happen, and when deadlines for filing claims or objections are set. They are entitled to attend the meeting of creditors, often called the 34th one meeting, where they can ask the debtor questions under oath. However, attending this meeting is not mandatory, and missing it does not mean losing your rights. Next, creditors must file a proof of claim to be paid from the bankruptcy estate. This document states how much money is owed and explains the basis of the claim. It is very important to file this claim before the deadline, which is usually around 90 days after the bankruptcy case starts. If you miss this deadline, you might lose your right to receive payment. Creditors are paid in a specific order set by law. Secured creditors who have a lien or collateral backing their debt get paid first, often up to the value of the collateral. For example, a bank with a mortgage on a property will be paid first if the debtor defaults. Unsecured creditors, like credit card companies or medical providers, are paid only after secured and priority claims are settled. In many cases, unsecured creditors may only receive a small part of what they are owed or nothing at all, especially in Chapter 7 liquidations. Creditors also have the right to object to the discharge of debts if they believe the debt was obtained through fraud or other misconduct. They can also challenge the debtor's proposed repayment plan in Chapter 13 reorganizations if they think it is unfair or incomplete. This helps ensure that creditors' interests are protected during the process. Another important right involves payments made shortly before filing for bankruptcy. If the debtor paid certain creditors within 90 days before filing, or within 1 year if the creditor is a relative or affiliate, the bankruptcy trustee can ask those creditors to return the payments. This prevents unfair advantages and ensures a fair distribution among all creditors. Finally, unsecured creditors often have the right to vote on the debtor's repayment plan and to help appoint the trustee or creditors committee. This gives them some influence over how the estate is managed and how debts are paid. To avoid mistakes, creditors should stay alert to bankruptcy notices, file claims on time, review filings carefully, and participate actively when needed. Missing deadlines or misunderstanding the order of claims can cost you money or your chance to recover what you are owed. Being aware of these rights and acting promptly can help you protect your interests during bankruptcy proceedings.